today is regarding some of our policies and the kneeling of the band. So we've asked our attorney to be here today, Mr. McIntyre, if he could speak specifically to these questions we've been asked. Thank you, Dan.
Sure, happy to. Thank you. So, just wanted to be complete. But I don't want to bore you with all of the terrible details of the First Amendment and what the courts have decided it means. It's one of the most complicated areas of law in our country, one of the most important areas of law in our country by most people's assessment. So the first place to start is, are there cases out there that deal with student speech in the school environment? And there are two critical cases. One dates back to the 60s, and then the other one was just a few months ago. And so there, believe it or not, 50-some years between those two cases decided by the U.S. Supreme Court when it comes to student speech. So the first question is, does the Constitution guarantee free speech rights to students in the school environment? The answer is yes. Everybody agrees on that. The courts have decided that. The U.S. Supreme Court recently affirmed that notion when they decided the case involving Snapchat and the former high school cheerleader earlier this summer. So there are some ways where we can regulate that speech in some context. So any kind of speech that materially disrupts our school environment, our ability to provide instruction, or invades the rights of others, we have the ability to regulate or restrict that speech. We also have the ability to regulate vulgar, indecent, lewd, obscene speech, any speech that promotes illegal drug use, speech that appears in a school-sponsored publication, like a newspaper or a yearbook, we have the ability to regulate. Any kind of serious or severe bullying or harassment, basically any kind of speech that threatens another student or threatens a faculty member, we have the ability to regulate. So I guess then the next question is kneeling during the national anthem considered speech? And the answer is yes. It's not pure speech, it's not the spoken word or the written word, but it's symbolic or expressive speech. The next question then is, can a school district regulate expressive or symbolic speech, like kneeling during the national anthem? And the answer is essentially only if it materially disrupts our school environment. Only if it really causes a substantial form of disorder, if you will. Now, the courts are very quick to point out that if the disruption occurs because of the way people react to it, then it is a disruption in a First Amendment way. That's simply a negative or bad reaction that can't be used against the person or people engaged in the speech in the first place. So then, what is a material disruption or a substantial disorder? It's something that obviously has to be decided on a case-by-case basis. All the courts that have addressed this issue have said that. But it involves some substantial inability on our part to deliver our services. To, in this case, have a football game. In this case, to show, play the national anthem for those in attendance. In the absence of that, there is no substantial disruption. The court has even said that even though people complain, even though people write letters, even though people feel heartfelt offense at the message itself, it's not a substantial disruption when it comes to the First Amendment. And that might be an unfortunate truth, but it is a truth nonetheless, and it's one that we're obligated to take into consideration when we look at these kinds of situations. There was a case that decided in federal courts a very similar issue. It involved a football team kneeling during the national anthem, and the court immediately decided that it was a First Amendment violation of those football players to say that they couldn't kneel during the national anthem, even though it was on school property and even though they wore the school uniform. And so the courts will often say the reason we hold public schools to this standard is because we're supposed to teach democracy here. And part of our democracy is the First Amendment. It is our First Amendment of our U.S. Constitution, and it's a very important lesson. Regardless of all of our own political views and our personal views and our life experiences, this is what the court required of us. And just to add a legal sort of reality to all this, if we're sued in a case that involves the violation of the First Amendment, we face two forms of damages, really. One is compensatory damages to the plaintiff, and the other is, if we lose, we pay the plaintiff's lawyers attorney's fees in their entirety. And so in that case I mentioned in federal court involving the football team and kneeling, the award from the court was $200,000. So they paid their lawyers, they paid the other side's lawyers, and that was what they learned in this whole situation. So I guess there's another really important lesson in all this, and that is, do our own board policies somehow restrict this? Because I think that's, Kathy, how you started this conversation. And when you look at 9700, it certainly speaks to political activity on our property. It speaks to partisan political activity on our property. That language, though, is really intended to restrict the board from authorizing the use of our property to be used for political purposes. The terminology used is the board shall not permit. Synonym for permit, definition of permit, is to authorize. It doesn't mean you shall not allow your facilities to be used in that way. We actually have other board policies, 5780 and 5780B, that speak specifically to our students' First Amendment rights of expression, and we say in those policies that we guarantee and respect them. So when you look at this situation, you have to back up and look at it from a very common sense standpoint too, which is, even if this board policy 9700 tried to prohibit speech on our property by our own students, the fact of the matter is the First Amendment prevails over our policies. In other words, we can't just legislate away the board policy that the First Amendment requires of us. And again, we may not like it, we may not like the message, we may not respect the message, but the courts have been very clear to say, as a governmental unit, we have to respect the right of people to give their messages. Now, a separate question on all this is, do we somehow tolerate the harassment of our students by other students, even by members of our faculty, if they choose not to engage in some form of student protest or some form of student speech activity? Absolutely not. And if we get a complaint of harassment, intimidation, bullying, retaliation, anything like that, we work very hard to implement our systems, and we have many of them, to investigate those complaints and get to the bottom of it and make sure that's not happening. Because we also respect the rights of our students to be silent, and we respect their rights to stand and to do what they want to do during the national anthem. So I'm happy to answer any questions you have. I hope that wasn't too much detail.
I do have a question. Thank you very much for that, Dan. That was very enlightening. One point that has been brought up was, apparently on Facebook, a member of the community aligned herself with the kids who were kneeling and said that a certain political group supported that. And this statement was used to try and say that that means that all the kids who are kneeling are part of this political group. Can you talk about that, please?
Sure.
Whether or not that is in fact true.
Right. So, I mean, I don't know what political affiliations our students have or their parents have or any of the people that might be involved in this situation. And really the courts don't look at that. They say, does the student have the right to engage in the free speech? The answer is yes, unless it's causing this substantial disruption, this material disorder in our school operations. And so it doesn't change the analysis in any way whatsoever whether the student or group of students is affiliated with a certain political activity, group, enterprise, effort, whatever. It doesn't really matter from the court standpoint. When somebody who has the right to engage in free speech chooses to do that on our property and it doesn't cause that substantial disruption, then we're obligated to allow it to happen. And even though again, this 9700 speaks in terms of we don't authorize, we don't permit our our facilities to be used for partisan political activities. That's not really what, this policy 9700 isn't really addressing that situation. And if I'm wrong, and I could be, the fact of the matter is we can't change the First Amendment and all of those obligations that the courts say we have to live by simply by adding a sentence to our policies.
So then the fact that a community member may claim what's happening as part of a political movement has absolutely no bearing on any of this?
None.
Okay, thank you.
I mean, it certainly does from a personal standpoint and how you view the speech and how we view the speech. And we certainly work with our students to make sure we're always trying to enlighten them as they're exercising their First Amendment and their other rights. We are an educational agency after all. But the fact of the matter is, you're 100% right, it doesn't matter one bit.
Thank you.
And somewhat related though, the district as an entity does not have the same abilities, correct?
That
Can
is
you
correct.
talk about an individual and their rights versus the district as an entity and the district property being used in this way?
Sure. So, I mean, it might be ironic to some people to look at it from that standpoint, but the fact of the matter is, you're right. We are not a political organization, and we don't, as an organization, engage in political activities using our school property, on our school property, using any of our equipment or other resources, even though our students have the right to engage in that political free speech type of activity. That's the legal reality for us. And the reason is that the First Amendment applies to us as a prohibition. We shall not abridge somebody's free speech rights. But it doesn't authorize us to do anything. It just tells us what we can't do. And the First Amendment guarantees somebody, an individual, certain rights. But the fact of the matter is, it doesn't stop anybody from doing anything unless you're a governmental unit. That's the thing about the Constitution. It applies to governmental units. First Amendment doesn't apply to any of you. It doesn't stop any of you from abridging somebody else's First Amendment right as a person, as an individual. But it does stop governmental units from abridging the personal, free speech rights of individuals. And, that's the part that sometimes gets lost in all this. And of course, it doesn't apply to private schools or private entities, again, because the Constitution only applies to governmental units. It was set up to restrict governmental units in there and how they function. And that's the First Amendment.
Any other questions for Dan? We thank you very much for saying
Thank
that.
you.
Thank you. Aaron Burnham. Welcome, Aaron.
Thank you. Good evening, board. Thank you for the opportunity to speak. My name is Aaron Burnham, and I am a member of this community. We moved up here, my wife and I, and my daughter and son 3 years ago. Felt compelled to speak. I am a member of the United States Navy Reserve. I've got 26 years of service. Today was a tough day. I was part of the team that brought HM3 Max Soviak home. I was planeside. I listened to his mother grieve on his flag draped casket. So I'm not here to try and drum up false patriotism or forced patriotism. And I do appreciate the attorney speaking and clarifying the First Amendment. I'm glad to hear that. I'm a big fan of the First Amendment. I'm also a big fan of the Second. I'm a fan of all the amendments, actually. Free speech is interesting to me. Things like burning the flag and wearing as many medals as you want to. It's all protected. And I understand that kneeling is protected as well. My question or my suggestion, I want to see if there's another method that these young children, and they are children, they're our children, can redirect and express themselves because it's hurtful. I'm telling you, your community, of which I'm one, and there are many like me, firemen, policemen, other ordinary Americans, you don't have to wear a uniform to watch a child kneel and be hurtful. And I appreciate, again, the attorneys, yes, it's hurtful, but it's protected. I understand that. I'm just teaching upon you and the leadership and the teachers to work with these children, okay? We just brought this young man home today, and in 2 days we celebrate, or not celebrate, 9/11.
I'm sorry, I have to cut you off. I got to stick with this 2 minutes or I get in trouble.
Miss Litch, I'll be a regular as well.
Okay, that's fine. Yeah, we'll see you next week then. Thank you. Yep, sorry, I keep everybody at 2 minutes to be fair. Let's see, next we'll have Rick Skanes.
I'm going to pass.
You're going to pass? All right. All right, thank you. Always feel free to talk to us next time. Let's see, if there's anything else for the board would like to discuss? If not, I'd like a motion to adjourn.
Would it be helpful for Mr. Winton to give us an update on where things stand working with the kids?
The kids, I don't know, if the board wants to hear anything or no? Well, maybe next time, let her hear some remarks.
They want us to speak or not?
Does anybody? Pardon?
Would you like to speak or not? I'm happy to do either. Whatever you guys want.
Okay, we actually would like to serve this week, and we have two minutes.
Ask him, yes, you've asked him to do it. Let's hear what Principal has to say.
Always good to hear from you, Rob.
I don't want people to think that this issue is going undiscussed or unnoticed.
All right, I got to be careful with what I say and what I don't say, so now I'll refer to any students in particular. But people have made it aware to me as well that they vehemently disagree with how the band has handled the kneeling, and I've also heard from people that are very supportive of it. So my position, the principal is to try to remain neutral and respect the free speech right to students, even though I do understand it causes people a lot of pain. With that said, I've worked with Mr. Caperta, the band director, to try to not prohibit students from doing this, but try to have at least start the conversation about how this looks optically. And especially as the gentleman so eloquently spoke before me with regards to the unfortunate passing of 13 service members of Afghanistan, and now we're coming upon the 20th anniversary of 9/11. Tensions are high, and I understand that. So what we've attempted to do is that try to have the students resolve or come to some sort of resolution on their own without myself or Mr. Caperta jumping in. And I do know that, according to Mr. Caperta told me that the band officers were going to be meeting with some of the members of the band who were kneeling to have a discussion today to see if they could possibly find a way to demonstrate or protest in another form. And I have no idea how that conversation went or how it will go on Friday, but the attempt is to try to resolve some of the issues with the students has begun, and they're good kids. I'm pretty confident that they can work through it. That's where we currently stand with them. Are there any questions I can answer for you?
Thank you, Rob.
Thanks.
Always do a nice
Okay.
job for us.
Take care.
Thank you for that. All right, motion to adjourn? So moved.